A wife just handed prosecutors the one document her husband's entire legal team swore didn't exist. 4 words, one voluntary submission, and the defense strategy built over 14 months collapsed before midnight. Here is what the coverage missed. The mainstream narrative tells you this is a marital dispute leaking into a courtroom. A private disagreement made public. Unfortunate, messy, personal. That is not what happened. What happened is that an independent legal team operating in parallel to one of the most closely watched defense operations in American legal history chose to walk into court and offer evidence nobody asked them for. Evidence that directly contradicts sworn testimony already on file. That is not a domestic story. That is a strategic legal event, and the implications stretch across every active proceeding this defense team is managing right now. Here is the number that frames everything. 14 months. That is how long Melania Trump's independent legal counsel had been operating separately from her husband's legal apparatus before last night's filing. 14 months of parallel proceedings, separate strategy, separate filings. While every public statement described unified family support and complete legal alignment, a separate legal architecture was being quietly assembled. And nobody checked the docket. That number matters because it destroys the accidental narrative. This was not a slip. This was not a document produced under subpoena, meaning under legal compulsion, where you can argue the other side forced your hand. This was a voluntary submission. Her legal team attached the communication as an exhibit, labeled it, and submitted it in the interest of full transparency to the court. Those are their words. Her team's words. Not a prosecutor's characterization. Not a journalist's spin. The filing speaks in the voice of Melania's own attorneys, and what that voice says is, we are handing this to the court because we believe it belongs there. Let that settle for a moment, because the legal distinction is not a technicality. It is the entire story. When evidence surfaces under subpoena, a defense team can challenge it. They can argue coercion, selective production, procedural impropriety. They have angles. When a spouse's independent attorney walks into court and volunteers the document, there is no angle. You cannot argue your own wife's lawyer was coerced into helping the other side. The voluntary act seals it. The communication becomes unimpeachable precisely because no one demanded it. Now here is what the document actually contains and why it landed the way it did. The communication in question is a private message sent by Melania Trump to her personal attorney. The message, as produced in the filing, reads, "He knew about it. Don't let them say otherwise." 4 words of substance. A direct declaration of knowledge sent to a private lawyer, time-stamped 11 days before Trump's own legal team filed a sworn affidavit in court claiming that no principal had advanced knowledge of the financial structure at the center of the case. Read that sequence again slowly, because this is where the legal exposure lives. Melania sends a message to her attorney saying, in effect, he was aware. 11 days later, Trump's attorneys certified to a court that no one in a position of authority had prior knowledge. The sworn statement came after her message already existed. That timing is not incidental. That timing is the exposure point. The question a court now has to ask is not simply whether Trump knew something. The question is whether his legal team, when they signed that affidavit, had reason to believe the opposite was true. That is the difference between a factual dispute and a potential ethical violation. And that is why, within hours of the filing becoming public, 2 senior attorneys from Trump's firm withdrew from the case. Attorney withdrawals are not dramatic gestures. They are calculated risk assessments. When lawyers resign from a case in the middle of active proceedings after a filing drops, it means they looked at what was just submitted and decided they did not want their professional credentials attached to what comes next. That is a signal, and it is one of the most legible signals the legal profession produces. But it gets worse, and this part received almost no coverage. 4 hours after the first message, in the same communication thread, Melania sent a second note to the same attorney. The content, make sure this is preserved. All of it. That is not a person venting privately. That is a person issuing a document retention instruction to her lawyer. She was not processing an emotion. She was building a record. And the attorney she sent both messages to had already received Trump Organization financial summaries more than a year earlier, meaning the attorney had context. Melania knew the attorney had context, and she still sent both messages, knowing full well what the attorney understood about the underlying situation. 2 messages, same thread, same day. First, he was aware. Second, preserve everything. Taken together, those are not casual texts. They are the architecture of an evidence trail constructed months before that evidence was ever needed. Subscribe. There is more coming on this, and the Friday hearing changes the scope of what we know. Here is what I want you to understand about how this moment got here, because the path matters as much as the destination. 14 months ago, when Melania quietly retained independent counsel, the coverage was almost universally dismissive. Routine, said most observers. Administrative convenience. Wealthy families often have separate legal representation for tax and estate purposes. Nothing to see. 8 months ago, when sources close to the Trump legal operation described Melania as cooperative but not involved in legal strategy, journalists accepted the framing without pressure testing it. 6 months ago, a Trump spokesperson stated publicly that Melania was fully supportive and that there was no legal daylight between them. That statement traveled everywhere. Nobody cross-referenced it against the docket filings from a separate jurisdiction that Melania's team had already submitted in March, filings that directly contradicted Trump's legal team's stated position on asset valuations in a Florida-based inquiry. 2 courts, 2 separate contradictory filings from Melania's independent counsel, and the public was operating on the assumption of complete alignment the entire time. This is the pattern that makes the voluntary production so devastating. It is not just one document. It is the culmination of a sequence that has been building for over a year in parallel across jurisdictions, in plain sight on court dockets, while the public picture was carefully maintained as something entirely different. When Trump's lead attorney received notification of the filing, his team requested an emergency delay in their own filing obligations. The request was denied within 40 minutes. By late that evening, 2 senior attorneys had withdrawn. Truth Social went quiet for hours, and Melania's team, rather than de-escalating, filed a clarification brief stating they were prepared to produce additional communications upon court request. The judge issued a standing production order the same night, requesting all communications between Melania's counsel and any party from January of the prior year to present. That is a wide aperture. And Melania's team did not object. They said they had more, and they offered it. Now think about what Trump's legal team faces. They have been managing multiple active proceedings under the assumption that they understood the full landscape of available evidence. They made sworn representations based on that assumption. And they have just learned through a public filing that their client's spouse has been holding documents for over a year across multiple jurisdictions and has been quietly producing contradictory evidence they had no knowledge of. They have been operating blind, and the court now has a standing order compelling production of what remains. Every case they are managing just became more complicated because they can no longer certify what they do not know. Former federal prosecutors and defense attorneys have been consistent on one point across every analysis offered since the filing dropped. Voluntary production cannot be challenged as coerced testimony. The moment the submitting party is the spouse's own independent attorney and the production is described in the filing as voluntary and unprompted, the defense has no procedural lever to pull. There is no motion available that makes this go away. The document is in the record, and the record is public. What makes this worse for Trump's team is the second message, the make sure this is preserved instruction, because it raises the question of intent across the entire timeline. If you are instructing your attorney to preserve all of it, you are contemplating future use. That message was sent months before these proceedings reached their current stage. The preservation instruction preceded the affidavit filing. The affidavit was filed by Trump's team. The math on that sequence is not favorable. And here is the response pattern that tells you everything about where each side actually stands. Trump's team called the documents fabrications and filed a motion to seal them. The motion was denied within 12 hours. The Truth Social post used the language of political persecution. The motion to seal was a legal mechanism, not a rhetorical one, and it failed procedurally. Every escalation this team has attempted since the filing dropped has been rejected by the court, which is itself an indicator of how the judge is reading the strength of what was submitted. Melania's team issued one sentence. Her legal team stands by all filings submitted to the court. Not a defense of the characterization. Not a clarification of context. Not an attack on how the coverage has framed the messages. One sentence standing by the filing. That is the statement of a legal team that knows exactly what they submitted and has no need to walk anything back. Melania has not appeared publicly since the filing. No joint statement, no coordinated appearance, no imagery designed to project unity. When a spouse wants to signal loyalty in a high-visibility legal crisis, they show up. She has not shown up. The silence between her team's one-sentence statement and Trump's multi-platform denials is itself a form of communication. Here's where this goes from here. There is a production hearing scheduled. The judge will determine the scope of what Melania's team must now hand over. 3 possible outcomes sit on that table. The narrowest outcome limits production to communications directly relevant to the specific financial transactions at issue, which gives Trump's team a defined perimeter and buys time. The middle outcome orders broad production of all communications across the full period covered by the standing order, which opens a record that could include dozens of documents across multiple matters. The most severe outcome involves a finding that Trump's attorneys filed a sworn affidavit with knowledge that contradictory evidence existed, which triggers bar referral inquiries and potentially restructures the professional standing of the attorneys who signed that document. Legal analysts who have reviewed voluntary production precedent suggest the middle outcome is most likely precisely because the voluntary nature of the initial submission signals to the court that more exists. If Melania's team was willing to offer this without being asked, the court has reasonable grounds to believe the full record is materially larger. Coming after that hearing, a deposition of a Trump Organization CFO who may now be cross-examined against the content of Melania's messages. Then a status conference on the civil fraud case. The first hearing after tonight's filing enters the record. And somewhere in there, whatever additional communications Melania's team offered to produce on request and which the court has now requested. The defense is no longer managing a story. It is managing a production order, 2 attorney vacancies, a standing court order, a multi-jurisdiction contradiction pattern, and the public record of a spouse's legal team voluntarily choosing to assist the other side. Here is the number I want to leave you with: 11. 11 days between the timestamp on Melania's first message and the filing date of Trump's team's sworn affidavit claiming no knowledge existed. 11 days. That is not a gap wide enough to claim the message was unknown. It is not a gap wide enough to claim the situation was unclear. 11 days is the space in which a legal team either knew about a contradictory document and filed anyway, or failed to ask the most basic question in any active proceeding. Does your spouse's independent counsel have anything that bears on the facts you are about to certify to a court? 11 days, and that question was apparently never asked. Or it was asked, and the answer was not what anyone wanted to hear. Here is the question you need to sit with. Every major political legal case in recent memory has relied on one assumption that goes largely unexamined: that family loyalty translates directly into legal alignment, that a united public front means a unified legal strategy, that when a spouse says nothing, they are saying nothing legally. Melania's team has been filing separately for over a year. The public assumed silence meant agreement. It didn't. What else have you been assuming about the cases you are watching right now that is equally untested? The 21st century legal landscape is not one with the loudest denial. It is won by whoever controls what ends up in the record. And right now, in at least 2 separate jurisdictions, the person controlling what enters the record is not Donald Trump's legal team. It is his wife's. The 4 words are already there. The preservation instruction is already there. The voluntary production is already there. The standing order for the rest is already issued. What is not yet known is how much more is coming. And what Melania's team said last night is that there is more, and they offered to produce it, and the court accepted. Friday's hearing sets the scope. Everything after that follows from what the judge decides in that room. The documents are in the record. Subscribe. I will break down what comes out of the production hearing the moment it concludes.